start recording again, and then I'll share my screen. And let me know when you can see my screen. Can you all see my screen?
Yeah, looks good.
Perfect. All right. Well, welcome to 21 in 21. My name is Mark Dumais, and I work, I'm a realtor who works at Boston Trust Realty Group. And today I'm hosting attorney Ali Maginat from MWA Law. And today we're going to be talking about the role of an attorney in real estate, in a real estate transaction, both a seller and a buyer, and what would you need an attorney for. So Ali will talk a little bit about his role, talk about some practical advice. We'll talk about the various contracts that you might encounter in a real estate transaction, both on the buyer and the seller side. What is 21 and 21? 21 and 21 is basically a campaign, an education, first-time home buyer education campaign that my broker and I had the vision to put together in order to help educate folks who are looking to purchase a home this year, in the year 2021. So our goal was really to bring in various experts in the various disciplines. We're talking about, someone, a mortgage individual person who basically you go to try to get a mortgage, try to get some financing. If you're looking to purchase a home, we've brought in, we're bringing in Ali Maginat, somebody from the law side. We're bringing in folks who are working in the banking industry, who are working also in financial planning. So the goal is to just really give everyone the tools, the necessary tools and resources that they might need if they're looking to purchase a home in the year 2021. So as I mentioned, we had Anne Rochelle, who about couple weeks ago had a presentation on basically the pre-approval process. She talked at length about it. And again, as I mentioned, if you're looking to watch the video for her, you just, I can send the information later where you can log on to the YouTube channel for the COPAD, and then you can find that video. After that, we had Felicia Harrison, who talked about credit repair. Obviously, some folks want to buy a home, but their credit may not be quite there yet. So she had a great conversation and a very engaging conversation with quite a few folks about what to do and how she can help with them get ready get their credit ready so they can purchase a home. And as I mentioned today, we have Ali Maginat, who's going to be talking about why you would need an attorney in the home buying process. And later on, we'll have Andre de Oliveira. He'll be talking about financial advising. Basically, if you're trying to purchase a home but your finances are a little messy, he's the guy to talk to and then try to get you to help you with different strategies to try to pay down debts, increase your savings so that you can be ready to purchase a home. And then we're also going to have Mike Reed, who is manager at a local bank in the area. He's also going to be talking to us about various banking services that a home buyer might need either before or after you purchase a home. So be on the lookout. We've set the link that you used to register for this talk here. If you scroll down more, you'll find the areas where you can register for any of these talks if they are of interest to you. And again, as I mentioned, my name is Mark Dumais. I am ready and willing and capable to help you with any real estate purchase or sell needs that you might have. And without further ado, we're going to pass it over to Ali. Ali, do you want me to share your slides, or do you have it ready to share yourself?
You can outline here. You can go ahead. You can go ahead and
share it for you. Okay,
yeah.
Perfect. All right, let's do this. Let's do this again. No. Oh, there you go. Share. What's going on here? Something is happening. Hold up. Okay. There you are. I'll try this again.
I have mine.
Okay, you try to share because for some reason mine is not working right now.
No problem. If you can allow me to share,
Okay, hang on.
I should be able to get mine up.
That part. Kind of saw it. It's a little weird that this is happening. Okay, hold up. Stop share. I'm gonna stop share and then you can start take over now.
Okay. Okay. Well, for some reason, it's not allowing me to.
All right, let me try again. I'm gonna close out of this one and then try to open it
No
again
problem.
on my desktop.
But while we kind of get the slides, I just wanted to introduce myself. My name is Ali Maginat. I'm a real estate attorney at MAW Law. I've been practicing for it's often more than a decade now, and it's been focused specifically in real estate. Been practicing both in New York City and now in Boston, and perfect. So here's my contact information. But yeah, I've been practicing for about over a decade now. My office is located in Chelsea. We just opened up an office in Worcester. And when I say we, is because it's not me. I'm not a solo practitioner, meaning it's me and we have 6 other attorneys on staff and a great team of support staff that helps us service our clients. Now, in terms of the typical clients that we have, it's anything from first-time home buyer to seasoned investor, and any type of property that you can imagine, whether it be a single family, multi, condo, commercial property, anything in between. We assist these types of individuals in both their buying and their selling. Now, I know we're going to go through a few topics today. Please feel free to reach out to me if there's anything after the presentation that you want to go over, but please stop me during the presentation if anything comes up, any clarifications. Now, what are we going to focus on tonight? Number one, just explain, everybody understands that, or I assume everybody knows that at some point there'll be an attorney involved in a typical real estate transaction. So we're just going to review what that means, who's involved, what their role is, and specifically, how can you leverage an attorney to benefit you as a buyer? Then we're going to talk about, really the nitty gritty of the legal aspects of the home buying process, and specifically what I call the 3 points of no return in a transaction. So you have the offer, which is the most critical and important aspect of any transaction because it creates the framework of the transaction. Then the purchase and sale agreement, which is the next legal agreement that the parties, meaning the seller and the buyer, would enter into. And then finally, the closing, right? The milestone event. You've done all this work, where you're going to make a bunch of promises, but and you're going to agree to, more importantly, repay all that money that the lender is giving you. But again, after everything is done, you get the keys. You are the owner of the property, and then kind of finish off with just a few practical things that any buyer should consider even after you become the owner. All right. So next slide. So I guess for me, all this information stems from the philosophy that I have, which is people that are informed and prepared tend to make better decisions and achieve greater success. And I think it's really important, especially in the home buying process, because when you think about, for a lot of people, buying a home is the single biggest financial investment that you can make in your lifetime. So if there's any takeaway that you can get from tonight, is make sure you're prepared, leverage people. You have great professionals like Mark, the people that he mentioned, whether it be credit repair, a lender, a financial advisor, leverage all these individuals around you to make sure that, you feel confident going into the process, but also that you feel that you can make an informed decision, meaning that you know the facts and you're willing to live with the consequences, right? Because you know all the facts and you're prepared, as you go forward through the transaction. Next slide. Now, I think it's just critical off the bat that for any buyer to understand that things are going to move quickly throughout a typical transaction. Okay, so really take the time even before you begin looking for a property or going to open houses. Really ask yourself, why do I want to buy a home? What is my true budget? Where do I want to live? What can I really afford? Again, these questions are questions that any buyer should ask themselves, but also critical that these are answered before you begin, because again, things are going to move quickly, and you don't want to be the buyer who's at the closing table who's asking himself or herself, hey, can I really afford this property? Okay, so really take the time to really think about these things. So again, use your, speak to your lender, speak to your financial planner or financial advisor, talk to your realtor. Maybe he or she can give you advice about, a good neighborhood, a good area of the state that you're not aware of. Maybe it's more affordable for you. So all these different considerations, leverage the people around you to kind of get these questions answered. The next important thing to kind of understand is that there's always going to be an attorney involved in the real estate transaction, especially if you're working for lender. The role of that attorney is to represent the lender, meaning doing all the legal work that's required in order for the bank to allow you to buy the property. Okay, that's their main role. Okay, and that includes title, making sure that there's no legal, and the most important aspect of that is title, making sure there's no legal defects that can affect your ownership of the property. So understand that, that attorney works on behalf of the lender. Now, what you need to consider is whether or not you want to retain an attorney to represent you as the buyer, which is to mean to represent your interests. So to assist you with preparing an offer, issues that can come up during a home inspection, reviewing, drafting the purchase and sale agreement, making sure that all the different deadlines, all the, that are going to be, that you're going to agree to abide by are respected, making sure that your deposit is protected if a commitment needs, your financing contingency needs to be extended, being there at closing with you to review all those documents. So really, that is the buyer's attorney. So when you're thinking about, do I need an attorney? Well, really what you're thinking about is to represent you as the buyer. And in most cases, that would require a separate fee, a buyer representation fee. But again, all that information, all that can be disclosed to you before closing. So when you're thinking about, the home buying process, the same way you may be shopping around from a lender or realtor, hey, it's not too early to start having a relationship with an attorney, somebody that could advise you on different type of legal elements that a typical transaction could consist of. So just keep that in mind, okay? Where do you find an attorney? Ask your network, friends and family, your realtor, your lender, there. But the takeaway here is that, do your homework, do your due diligence, find somebody that matches your budget, your personality, but also to have a clear understanding what they will or will not do as your buyer's attorney, because not all attorney will do the same type of work, okay? Right. Now, the second thing on the next slide is to just consider that, different type of property have different considerations, right? So if you're thinking about buying a single family, that's great. But if you're buying a multifamily, that has a whole different level of responsibility that you're taking on as a buyer, right? So number one, as buying a multifamily, is that presumably you're going to be a landlord. Okay, so do you understand what it means in terms of that responsibility? Okay, that's again a conversation that you may want to have to an attorney, so you understand really what that means. Okay, now the other aspect of buying a multifamily could be the fact that you may be possibly inheriting tenants. Okay, so when you're going to the open houses, when you're preparing to make an offer, have you done your due diligence? Have you requested the appropriate information from the seller to make sure that you're making an informed decision because you understand the situation that you're entering into? Okay, because if you're going to inherit tenants, that means that good or bad, whatever the situation is with these existing tenants, is a situation that you're going to inherit. Okay, so you want to make sure that you're requesting the appropriate information so you can again do your homework, you can do your due diligence. Okay, now if, for example, instead you're focusing on buying a condo, which is great, well, understand that that's a different type of ownership, right? Because as a unit owner, you share in the common expenses that the condominium has, right? Now, common areas could be things like, a driveway, the hallways, but if you're buying in a much bigger development, that could be a gym, pool, more amenities, so that has more costs. So again, as a buyer of a unit, you're going to share those costs with the other unit owners. So you want to make sure you understand, what does that HOA look like? What does that cover, for example? also, as part of your due diligence, understand that no seller is going to guarantee you that your HOA fee is going to stay the same during the course of your ownership of the unit. The job of any of your realtor or your attorney is to make sure that information is requested that could give you an idea as to whether or not there's anything in the near future that could lead to an increase in the HOA fee. Okay, so again, that's part of the due diligence, but also that's part of the homework that you need to do as a buyer to prepare yourself that you're asking the right information, either while you're making an offer or while you're doing your due diligence after an offer is accepted. And then finally, just want to talk about briefly about people that are maybe thinking about, I've heard about doing a short sale. What does that mean? Because I think maybe that's a good deal. Well, a short sale means that you are buying a property that's underwater, meaning that you have a seller who may be in some sort of pre-foreclosure situation where they've maybe behind on their payments, but instead of foreclosing on the property, the lender says, you know what, we know that you're behind on your mortgage. You may owe more money than the property is worth. For example, the property, they owe $600,000 on the mortgage, but the property is only worth $500,000, meaning that if they were to sell the property, there'd be not enough money to pay off the mortgage. So in that scenario, the lender says, you know what, we'll do a deal with you. We'll allow you to sell the property at a lower amount, and we'll take less just in order to not foreclose and all the costs and delays involved with that kind of process. So as you can imagine, that means the lender is taking a loss. That means also that there may be a lot of red tape before that transaction gets accepted. So if you're a buyer who's not flexible on their timeline, then it may not necessarily be the transaction for you. Okay, so keep that in mind. And also, it's subject to the bank's approval. So you can be into short sale for like 2 or 3 months, come to find out at the last minute that the lender rejects or doesn't approve the short sale. So again, if you're not flexible, it may not be for you. The other type of transaction you may want to consider is if you're buying a bank-owned or foreclosed property. Again, any buyer wants to have an opportunity to do the due diligence, meaning going to the property, doing an inspection. That may not necessarily be available for you as a buyer of a bank owner foreclosed property. So again, if you're not going to get access to the property, you may not be able to do your due diligence. And let's say fast forward at the closing, you get the keys finally, you open the door and come to find out that the whole plumbing system needs to be replaced. That may be a huge hit on your budget. So again, if you are somebody who's tight on their budget, doesn't have a lot of wiggle room in terms of expenses related to the property once you buy, that may not necessarily be the type of property for you. Okay. The other, example could be that if you're buying a bank-owned property or foreclosed property, the lender may make you responsible for certain cost expenses that a typical buyer would not be responsible for in a typical transaction. For example, outstanding tax bill, water bill. Okay, so you may not be, you may be online, bidding online on the platform like auction.com, clicking away and not realizing that you are accepting to take responsibility for certain expenses that a typical buyer would not be responsible for. Fast forward at closing, the closing attorney says that your closing costs are $5,000-$10,000 more than you expected because you agreed to take responsibility for certain things that a typical buyer would not be. So again, this is not to dissuade you from considering these type of transaction, but if you are, lean on your realtor, lean on your attorney to make sure that before you actually commit fully, you understand what you're taking responsibility for, which differs greatly from a typical buyer. So just something to keep in mind, or if these are the type of property that you may be thinking about or considering. Okay. Now, all these discussion leads us to the next slide and what I think is the most critical aspect of the transaction, which is the offer, right? So just so you understand the mechanics of an offer, right? Let's say Mark is a great realtor. You go to open house, he's identified the house of your dreams. You go see it, you love it, and you actually want to buy it. Well, the offer is the actual document that Mark is going to prepare that's actually going to contain the basic elements of the transaction. So anything you can think about, whether it be price, the commitment date, the financing date, all these different contingencies that an offer can have, all that will be included in the offer, okay? And literally, he's going to complete a document, submit it to the listing agent or the seller directly, at which point the seller will have 3 options: either accepting your offer, great, you're under agreement; rejecting it, too bad, they wanted to go with somebody else, or saying, listen, we like your offer, but maybe we want to increase the price, the purchase price by $5,000 or $10,000, at which point you as the buyer have the option of accepting or rejecting that counter offer. But, once you have, that agreement, right, either accepted or accepted the counter offers, you're under agreement, right? And it's important to understand that legally, that document that you're gonna offer to the list to the seller, once it's accepted, you can't really alter the terms of that offer, right? So again, the takeaway here in terms of the offer is just to understand that it is going to be the most important document that you're going to sign in your transaction. Okay, so again, whether it be understanding, what the good purchase price is, understanding what it means to have an inspection or waive the inspection, understanding what it means to what it means to have a timeline for your financing or closing date, making sure that there's different contingencies if there are tenants, if you're buying a multifamily, if you're buying a condo. So all these things you need to understand. So when you're actually in a position to make the offer, you have identified the key things that need to be included, and you can feel comfortable that everything has been covered. So again, when we talk about the importance of having a conversation, whether it be an attorney or a realtor, a loan officer, all these people can help you identify all these different elements so you can feel confident when you're putting together your offer. Now, again, although it's a legal binding agreement, it doesn't have to be completed by an attorney. But I would suggest to all of you is that the benefits of establishing a relationship with an attorney early on is that if you're working with Mark, for example, and you're ready to put an offer together, you could say, well, let me run it by my attorney, or maybe give his advice to make sure everything's included. All that's perfectly fine. But again, it's those who are prepared, who've established a relationship, can actually leverage that kind of professional perspective to make sure that they feel comfortable going forward. So just something to keep in mind. But once you have the offer, right, things are put together, right? Meaning you have a binding agreement, but there might be some contingencies, meaning you have to do an inspection. Maybe the seller has to give you more information that you want to review. Getting in, and again, that's the first point of return, because at that point, right, even if you're under agreement, there is a possibility for you to walk away from the deal if you get information or the inspection doesn't go as planned. So you still have an opportunity to move to back out of the transaction and get back your initial deposit. But understand is that if you are moving forward, it will get you to the second point of the transaction, or legally, which is the purchase and sale agreement. Okay. Now, the purchase and sale agreement is the second agreement that you're going to sign with the seller. But understand that everything that you've agreed to is going to be incorporated in the offer. So the purchase and sale agreement is not an opportunity for you to renegotiate the terms of the offer. That's done. The purchase price is the purchase price. Okay. Again, there could be a scenario where you did an inspection that you negotiate some repairs or price reduction, but that's not a rule. That's just a case by case. The seller may say to you, hey, I don't care if the inspection went badly. I'm not budging on the purchase price. I'm not agreeing to make the repairs. At which point you can decide whether or not you want to move forward or not. But the purchase and sale agreement is the next agreement you're going to sign with the seller. Again, nothing changes in terms of the terms, but there's some added representations or promises that the seller is going to make and you as the buyer are going to make. For example, the purchase and sale agreement specifies that this is subject to the seller providing clean title, meaning if the title is not clean, you have no obligation to buy. You, in fact, cannot buy this property because your lender is not going to allow you to do so. There's going to be language that says that the seller has to provide a smoke certificate from the local fire department prior to closing. But as the buyer, understand that the most important promise that you're making in the purchase and sale agreement. Okay, so if you're working for a lender, you're going to have to apply for a loan. Okay, and the idea is that within a certain amount of time, the lender is going to approve your loan. However, there could be a scenario where by the deadline agreed to in the offer, the financing is not ready, at which point you as the buyer, only option is to request more time. Okay, because if you don't, you've in fact waived your contingency and you're communicating to the seller that you're ready to close. So for example, if today was your deadline for financing and you didn't request an extension and your closing date is Friday, the seller expects you to perform on Friday, meaning show up with the money at closing because you haven't requested more time. But the seller has two options, either giving you the time you need or rejecting your request and giving your money back. But the takeaway here is that it's an important deadline. Again, that's one that's going to be handled by your attorney, meaning your attorney is going to send you appropriate extension if when required to make sure that your deposit is protected. Just in a practical standpoint, once the purchase and sale agreement is finalized, I like to review it with my clients. Before COVID, we would meet in person, but at the very least over the phone where I can send it to my client, we can take 15 minutes to review it because again, at this point in the transaction, away from the transaction if you wanted to, right? And the worst thing you could lose is your initial deposit. But once you sign the PNS, it's the second point of no return because next stop is closing. So again, critical document to review, understand as you move forward in the transaction. Now, I guess we'll fast forward to the next slide, to the next two slides. All right, we can skip that just to the PNS, which would bring us to the closing. Now, getting to the closing table assumes that you have your financing. So understand that you may be denied, which is okay. If your lender denies you for whatever reason, you're entitled to get your deposit back. But getting to the closing table assumes that your financing is all set. Now, just briefly, a few things to keep in mind before you actually get to the closing. You're gonna do a final walkthrough, right? Because you actually want to go back to the property and make sure that the property is in the same condition it was when you made your offer, right? Also, you want to make sure it's in broom clean condition, right? No, all of the seller's items have been removed from the property, okay? And also, if there are other deliverables, for example, the seller had to make repairs or the seller had to deliver some of the units vacant, you have an opportunity to go back to the property to verify that that's been done, okay? If it's not, obviously you'll talk to your realtor, but that's when your attorney gets involved to make sure that, hey, what are we going to do? Because again, if the property is not delivered in the condition that it was agreed to, you don't have to move forward with the closing. But we'll find a way to address that concern either by delaying the closing, which is not the solution that we like, but maybe doing a holdback, right? Meaning that we keep some of the seller's money in escrow until whatever the seller agreed to do has been completed. For example, it could be as simple as you haven't emptied out the basement. So we're going to keep $500 to make sure that within 24 hours you do. And we're going to keep $500 of the seller's money. And if they don't do it within 24 hours, you get to keep it and it becomes your problem. Or it could be more complicated, for example, if it's a tenant situation where a tenant hasn't vacated. But again, all that has to be addressed prior to the closing table to make sure that that whatever was agreed to has been delivered. Other key thing to note is before closing is that the lender is going to give you your CD, your closing disclosure. That's going to give you a breakdown of all the cost expenses related to your transaction because unfortunately it costs money to borrow money, right? So one thing to note is that before you actually, once you sign your PNS or have an offer in place, your lender is going to give you an estimate of what your closing costs are going to be. But it's not until the closing disclosure is issued prior to closing that you're going to get the final figures that gives you all the cost expenses, but also gives you details about your loan amount, your interest rate, your principal interest payment, your escrow, right? Because one of the things the lender is going to require you is to pay money towards your escrow, meaning money that you're going to pay every month in addition to your mortgage payment, your principal and interest, to cover your taxes and insurance. So that's going to be also disclosed to you in your closing disclosure. One thing to keep in mind is that closing assumes that title has been cleared, and there's going to be something available to you as a buyer called title insurance, meaning that although this closing attorney is going to guarantee you that the title is clean, humans did the work, humans make mistakes. So you as the buyer have the option of purchasing your title insurance, meaning that you would buy insurance that protects you for any title issue up until the day of closing. Now, the way it's a one-time premium, it's based on your loan amount, but understand that although it is optional, that is not an area of the transaction where you want to save some money, okay? Because again, if you do not purchase your own owner's title insurance, and let's say 5 years after closing, you decide to sell the property, and the next buyer says, wait, there's a title issue that predates your ownership of the property, you can't go back to the seller and say, well, now it's the previous seller's responsibility to fix it. It's going to fall on you as the current seller to clear any title issues from before you became the owner. And if you don't have title insurance, you're going to have to pay out of pocket. And that can be very costly and expensive. So just something to keep in mind, whether or not you're thinking about that.
I have a question there.
Yeah.
Did I hear you mention that the lender is themselves purchasing title insurance, but you have to purchase one separate one yourself? Is that what you said?
Correct. So there's two types of title insurance. So there's a lender's title insurance and there's your owner's title insurance.
Mhm.
As part of your closing costs, your lender will require you to pay their lender's title insurance policy.
But it doesn't cover you.
It does not cover you. And the
Okay.
reason being is because in the event that you don't pay your mortgage and they have to foreclose on your mortgage,
Mhm.
the idea is that the lender will foreclose, sell the property to somebody else, get their money, and then repay themselves for your mortgage, right? That's the basic
Exactly.
concept of foreclosure. It is possible that during that foreclosure process, there is a title issue that comes up.
Mhm.
The lender wants to be able to indemnify themselves by using the lender's title insurance that you paid for.
Yeah.
Because it's for their benefit. Now, understand that does not extend to you as the owner. That's why you have the option of purchasing your own to protect you. And sometimes, because sometimes the lender's title policy is always there, sometimes people show up and realize, and there's a title issue, and then the buyer's like, the seller says, oh shoot, I have a title policy. And come to find out, no, you didn't purchase one. You only purchased the lender's one, but we can't locate a owner's. So again, your attorney can explain to you what that means. But again, the takeaway here is if you're trying to save money, that is not one where you want to save a few $100s in order to save some money because your closing costs.
I want to flesh this out a little bit, just a little bit. Can you help us visualize like an actual example of an issue that could come up that has to do with title, some defect in the title? So just so people can like,
okay, for example,
feel and see it. Mhm.
You are, when you bought the property, right? The seller had a few mortgages and money was collected at closing to pay the mortgage. And once the mortgage was paid off, a discharge had to be recorded indicating that that mortgage was paid because money was collected to pay that off. So the closing attorney or the lender was supposed to record in a corresponding discharge saying they've received the money and the debt has been paid. Unfortunately, sometimes what happens is that fast forward a few years, although the mortgage was paid because money was collected at closing to pay that mortgage, no corresponding discharge was recorded. So you as the buyer, you as the seller show up and say, wait, I know money was collected. How come there's no discharge? At which point you will be responsible to actually track down that company and get the discharge. Now, sometimes it's as simple as contacting Chase, Bank of America, Citizens Bank, and they'll issue that discharge because they have the records and you can provide some sort of closing statement. But I've had a situation where it was a mortgage company that no longer existed. Because the mortgage company was a mortgage company and they went out of business. So now we have to track down, somebody from this company that was no longer in business for over a decade, and we had to track it down. It can become complicated. Luckily, we were able to track down that guy in like New Hampshire. But that was the simple example, right? But it could have been more complicated where we could not have found somebody. Now we would have to go to court and request some sort of discharge. So
yeah,
that's an example. I mean, I have another example where I was representing a buyer where the seller acquired the property 20 years ago. And when they acquired the property, they acquired it from a couple. But in fact, at the time this couple transferred the property to them, that couple was in fact not the owner of the property. The property was being held in a trust. Somebody made a mistake. Somebody didn't catch that. We're now dead. So it was 20 years ago. So they're now dead. And the trust doesn't specify who is to be appointed as a succeeding trustee. So now these sellers, because they don't have an owner's policy, they actually have to go to court to go and make a determination as to who should succeed as trustee. That could take months, that could be costly. So again, a huge title issue just because somebody want to save a couple $100. So again, it could be simple.
Perfect. Thank you. No, thank you. Thanks for fleshing that out, because it's something that I always I mentioned to my to buyers, and it's always a bit of an exercise to explain to them the importance of it.
Yeah, and again, if I had a buyer who was looking to waive it, in fact, I'd make my buyer sign at the closing table a disclosure that says that I've advised them not to. So, because sometimes what happens that the buyer says, "Well, no, I thought I did," and so I advise them against them, so they can come back and say that it wasn't offered to them or they wanted to pay it, but something like that. So just something to keep in mind.
Perfect.
Now, just one note after that, you're going to sign a bunch of documents at closing. The note is a promise to pay. The mortgage is the document that allows the lender to foreclose on the property if you don't pay your note. The homestead is a benefit that as a homeowner you have in Massachusetts, meaning that automatically, without doing anything, you're entitled to up to $125,000 in equity protection against unsecured creditors. Meaning, if you owe money to, let's say, a credit card company, a car note, hospital bills, and these creditors try to make you sell your property to pay them back, well, you're protected up until $125,000 in equity. By doing the homestead, and again, you get that protection without doing anything. But by doing the homestead, you bump up that protection to $500,000. So again, a benefit that you should take advantage of. In fact, the state highly encourages any homeowner to do that because, in fact, it's for your benefit. But keep in mind that that's for unsecured debt. You still need to pay your taxes. You still need to pay your mortgage. It does not prevent it. It's still it doesn't protect you against your obligation to pay child support or spousal support. It's strictly for unsecured debt. And then finally, your deed. Okay, just a quick note that there's different title, meaning that if you're a spouse, you and your spouse can hold title by tenants in the entirety, meaning if something happens to your spouse, the property automatically goes to you or vice versa. Or if you're not buying property with a spouse, for example, you're buying it with a family member or a girlfriend or boyfriend or a significant other, you can hold as joint tenants, which is the same concept where if something happens to you or the other person, the property goes to the other person or to you, vice versa. Or you can be tenants in common, where you can say that everybody owns 50-50, meaning if something happens to you, the property automatically does not go to the other person with who you hold the property and tenants in common. So again, these things can be discussed with your attorney, especially if you're buying with a family member, friend, etc., business partner. So again, your attorney explain to you what that means, and you can make a determination as to how you want to hold title at that point. But you'll sign it, but you're not going to be the actual owner of the property until the deed and the mortgage is recorded. Okay. Perfect. Now, just to wrap up, that sort of, I'm going through these, rough points, but, one thing to keep in mind post-closing, right? Which is, make sure, all these different things, like we were talking about, understanding your needs, understanding what your true budget is. All these things come into play after you close, because once you become the owner of the property, you're responsible for these carrying charges, right? Whether it be, think beyond of your mortgage, right? You have your water bill, you have your internet, you have maintenance, you have repair, upkeep, landscaping, snow removal. All these costs are the true cost of ownership. So just keep that in mind when you're doing your homework in terms of talking to your lender, your financial advisor. Just make sure you understand what the true cost of ownership is. You also may want to consider some sort of basic estate planning, right? Whether it be term insurance or whole life insurance. All these kind of financial products are useful in the event that something happens to you or to a family member, or you're disabled, you can't work. So again, talk to an insurance agent. Make sure you understand what kind of options are available out there to protect yourself. And then finally, for any couple, right, buying a home is probably the most significant purchase they'll make. You may want to think about maybe doing a prenuptial agreement, right, where you and your spouse, knowing that you'll get married, you already decide what will happen to your property that you acquired during the marriage in the case of a divorce. Okay, because again, if you're married and you own property, that house, that property will have to be equally divided, right? So again, you can do a prenuptial agreement just to before you even become married, legally married, to kind of decide how you're going to address that property. So just something to keep in mind when you're thinking about ownership with a spouse, for example.
So that's something you would probably do either prior or
Oh yeah, so
purchasing the property or after?
Prenup is prior to getting married. It's a contract between you and your spouse. It says exactly what's going to happen to your property in case of divorce. It's a voluntary agreement. Let's be clear, meaning you can't force your spouse to sign this and threat your friend, your spouse, not to get married without them him or her signing this document. So just something to keep in mind. But yes, it is signed before marriage, before legally married.
But I love her. Okay.
But something to keep in mind. I mean, there's different ways, different concerns. So, the takeaway here is that, again, that's something you can discuss with your attorney, but something that can be available to any buyer who's concerned about these kind of, and these things are not out of the ordinary. Just to be clear, people do prenuptial agreement. It's not something that's unusual. It's not for the rich and famous. People can do it all the time, especially if you have concerns about the division of property or asset or any other asset. It can extend to anything else beyond the home itself.
Yep.
All right. So that's in a nutshell the main point I wanted to cover. Again, this is not meant to be the nitty-gritty of the home buying process, but just give you some ideas, things to think about, and kind of emphasize again that for me, buying a home is all about preparation, right? Use people. There's some great professionals that are going to be participating in this program. Start having conversation. If you've identified the type of property that you want to buy, start having a discussion about buying a multifamily. What does it look like to be a landlord? If you know that you're concerned about your budgeting and what you can afford, hey, have a conversation with a financial advisor. All these resources are available to you because, again, I'll leave you with this note is that things are going to move very quickly once you're under agreement. So all these different issues that we've talked about, need to be addressed before you're at that point. So again, lean on these people around you, get informed, educate yourself, and, do what you need to do so you can feel confident, moving forward with the home buying process.
Yeah, no, I'll definitely second that point. I get a whole lot of questions, and sometimes I feel like you said, if had people been better educated about the process, some of these questions, at the time I probably wouldn't get them, and oftentimes there's always a time crunch, to find out some of that information for the buyers. But if they had, if there was some homework done, if there was some education prior to getting into the process, it would have helped quite a bit for both me and the buyers.
Absolutely,
that's definitely a great point there. I do have a question. You did mention about. Well, let me first of all open it up to the group, to everybody else. If there are any questions, and if you're shy to speak, you can put it in the chat. I'll read it out to Ali. But I wanted to just open it up to folks. Give it a minute.
I have a quick question. My name is David. I came a little late, but I see that you guys are recording. Is it going to be posted somewhere for?
Yes, this will be posted on. I should have your email address from your registration, from registering, so I can definitely send you the link. It's going to be posted on the COPAD YouTube channel. So if you also go to Instagram and then go to the COPAD page, you can definitely find the link there, so you can definitely watch this afterward.
Okay, perfect. Thank you.
No problem, sir. So my question, Ali, is really a little bit more specific to helping me and maybe anybody else here understand why would I need to get my separate attorney if the bank is really, like, how do my interests in that of the bank compete? Or does it compete?
Good
Or is
question.
it, what's the reason there?
It's a good question. So the lender, the job of the bank, the lender's attorney is to clear title and to prepare all the documents that you're going to sign at closing and to handle the settlement, meaning collecting all the money and paying everybody involved in the transaction. That's their job. So while you as a buyer, it could be aligned to the extent that the lender wants you to close, right? But they're not protecting, that does not extend to protect your interest, meaning all these issues, for example, identifying, whether it be negotiating repair issues, negotiating the fine points of the PNS, sending extension requests on your behalf. That although they have an incentive for the transaction to go through, they're not there to make sure those things happen on your behalf. So any attorney, that's a good note. Any lender that tells you, hey, my closing attorney, which everybody understands now that is going to be involved in transaction, will also represent your interest for free. That's not, I think that's, again, the same way you do due diligence, you get what you pay for, right? So, some lenders do it and it could work out for you as a buyer. But I also have the reverse happen where buyers say, you know what, I'm good to go with the lender's attorney. And when something happens along the way, they turn to the lender's attorney and say, well, can you step in here? And the attorney says, well, no, my role was limited to you signing the PNS, for example. My role is limited to make sure that you show up at closing, but I'm not going into the nitty gritty of the disputes regarding the PNS. That's not their job. Like the attorney will give it to you, will maybe say, hey, sign this document, but they're not going to review it with you. They're not going to negotiate the terms. So again, for most of my clients, I do both roles, meaning I am both the lender's attorney, I am also their attorney. But all that requires a separate fee and a separate retainer agreement, meaning that will be disclosed to you. What I do will be disclosed to you, and you can decide as the buyer whether or not you want to return my service. This is not something that you're obligated to do, but whether or not you work with me, any real estate attorney, you will be paying him or her a separate fee to represent you as the buyer. Now, the fee can differ, and the type of work they'll do could change a little bit. But again, you're the buyer, you're the consumer at that point, meaning you can shop around and figure out the best fit for you. Some attorneys may be cheaper, some may be more, some maybe work by the hour, which is very rare. We charge a flat fee that's payable at closing only, meaning that it doesn't matter if you and I talk every single day during your entirety of your transaction, it's still the same fee payable at closing. Some attorneys may charge more or less, but again, you're the consumer there, so you can shop around and figure out what's the best fit for you. But the takeaway here is that is quite, representing a buyer, representing your interest is quite different than representing a lender. That does not extend, I've not seen any attorney, the attorney who's not charging you a fee is not they're not representing your interest. They're not, even if they say they do, they're not, you haven't retained them. You're not under agreement. There's no representation agreement between the two. So there's nothing for you to refer to in the event that there's a dispute with you and your attorney. There's nothing for you to come back and say, well, you're my attorney. That's not, again, you'll have to engage that attorney separately. So just something to think about, and certainly something that could, if some people need clarification or want to discuss what that looks like in real life, yeah, I'm available to have the conversation.
Nice. Any other questions from the audience? So you said you have several offices. Where exactly are they located? How would somebody get in contact with you if they?
So we have an office in Chelsea, which serves Greater Boston area. But we also just opened up an office in Worcester to better serve our clients who are looking in the Central Mass. So anybody who has any questions, follow up, please feel free to reach out to me. Sometimes people have this misconception that, to get me on the phone or to ask me some questions, all of a sudden that they're going to request some sort of retainer agreement. It's not the way I work. So, I have conversations all the time with people that are either in the beginning of the process, who are thinking about it, and we just have a conversation. And the benefit is that once they've identified a property, I can quickly get involved, whether it be reviewing an offer, connecting with their realtor, troubleshooting some things that came up during the initial walkthrough, or anything. So again, the earlier the better. And people all the time. And again, it doesn't mean that you're committing to working with me. There's no formal agreement, but just something to think about for those who are trying to figure out, like, how does that work practically in terms of talking to an attorney, or when do I need to start talking to an attorney? Does it mean I have to pay you? These are all good questions, but that's not the case. I'm here to help, assist, answer any questions you may have. And if ultimately, once you do under agreement, you decide to work with me, great. If not, that's okay.
Yeah, that's a good point. How, like you said it's best to engage you as early as possible. But when is the last possible moment that you should engage an attorney?
Well, engage. Somebody else. I wouldn't say. Let me clarify. Anyone can contact me, discuss things that we talked about tonight, but really, the buyer will not actually engage me until they're ready to sign the purchase and sale agreement.
Exactly. Okay.
So, in fact, I get the offer. I can work on the PNS, and then the buyer says, "Hey, I decided to work with somebody else." It's okay. Like, we're not actually working together or actually retained until you're ready to sign your PNS, your purchase and sale agreement.
Okay.
So, which is, when you think about it, there's a number of other steps beforehand before you get to that point. It's just something to keep in mind.
Yeah, exactly. Yeah, it's good. We have a shy audience this time.
I did a great job.
So, but no, we're at 7:31, and I know that this we had scheduled this call to be about an hour. So, at this point, if if anybody needs to log off, that's fine. But we'll give it another 30 seconds or a minute if anybody has a question. I don't see anything in the chat, so I'm assuming no one has a question. That's also compliment to you, Ali, that you've done a great job explaining.
But all due seriousness, though, these topics, it can be a little nitty gritty, specific. But I would encourage all of you to take the time to lean on the people around you. There's some great Mark is a great guy, very great resources, your lender, etc. Lean on these people, educate yourself. This process can be challenging, and as a final note, my wife and I closed on our first house right before New Year. And again, as somebody who's been practicing law for over a decade now in real estate, it was not an easy process. We had to go through the same kind of exercise that any buyer would go to. We had to sit down and figure out our budget, figure out where we wanted to live, figure out what were items that be non-negotiable, things that were important to us. And again, these are not easy conversations. So take the time to really think about that. And to be honest, when we got to the closing table, it was really a great achievement and really a highlight of our relationship. So something to think about. Something to think about. Get some perspective. It can be challenges. It can be complicated and frustrating, but take the time to prepare yourself, and you'll do just fine.
All right. Well, thank you all for your time. Thank you, Attorney Ali. I will let everybody who was on this call, I will send them. Can we share this, or do you have any material?
Yeah, sure then. Yeah.
Okay.
Please, yeah, and please share the slideshow. And my contact information is on the first slideshow. So my cell phone, my email. So please feel free to reach out to me.
That's exactly what. Okay, perfect. I will send that over to everyone who had who was on this call and registered. So, and then contact both Ali and I if you have any real estate services needs for real estate services, both legal and purchasing a home.
All right.
All right. Thank you all for your time. Thank you.
Yeah, thank you so much for your time and attention. Have a great evening.
All right. Bye-bye.
Bye.
All right. Can I end the call? There you go.